Hello. In today's lecture, we are going to understand defamation, essentials of defamation, what are the defenses available for defamation, and so on and so on. Now, before understanding other concepts, let's understand it clearly that defamation basically means an injury to the reputation of a person, what we call in layman's word as goodwill or image of a person in somebody else's eye. That is what defamation. So, defamation is injury to the reputation of a person. An injury caused to the reputation of any person amounts to defamation. If a person injures the reputation of another, he does so at his own risk, as in the case of an interference with the property. So, when you damage a property or cause any injury or risk to the property, it is actionable under law. Similarly, if you damage somebody's reputation, that also becomes actionable in law. A man's reputation is his property, and if possible, more valuable than the property. The image which a man holds in the society, his standing, his holding in the society, is more valuable than any other property. And in England, so basically, we will first study a little about the English law. Why do we study about English law always when we study torts? Because that's where it has come from. So, in English law, it is divided into libel and slander. So, there are two categories of defamation, libel and slander. Now, what is the difference between this? Slander is the publication of a defamatory statement in a transient form, that is, in a temporary, transient form. It may be by spoken words or by gestures. So, any publication of a defamatory material in a transient form or in a basically in a temporary form becomes a slander. And what is libel? It is in a permanent form. So libel is the representation in some permanent form. It may be in writing, picture, edify, statue, etc. In a cinema film, not only the photographic part of it is considered to be libel, but also the speech which synchronizes with it is also a libel. So not only the picture, because you might say that this verbal or speaking parts are slander. But no, that's not the case. Why? Because if it's a film, it's recorded. So when it's recorded, both the parts become libel. Another test which has been suggested for distinguishing between libel and slander is that libel is addressed to the eye and slander to the ears. So libel is to the eye and slander is to the ear. Why? Because it is in transient form and it is spoken of by gesture generally. Now, under English law, the distinction between libel and slander is material for two reasons. Why two reasons? First is that under criminal law, only libel is recognized and not slander. So if you write something, then it is a defamation, not if you speak something. Under tort law, slander is actionable save in exceptional cases only on the proof of special damage. This means that general rule is that slander is actionable only in the case of proof of special damage. So you will have to prove that there's some special damage which happened to you, unless and until there are some exceptional cases where slander is also made actionable. Libel is always actionable per se without any proof of damage. So irrespective of any damage, it is actionable. Now, in the following four exceptional cases, slander is also actionable per se. Last slide we had read that slander is actionable on special proof except in certain circumstances. These are the four exceptions. First is imputation of criminal offense to the plaintiff. So you impute that the person has done something illegal or criminal in nature. Basically, criminal in nature. Imputation of a contagious or an infectious disease to the plaintiff, which has the effect of preventing others from associating with the plaintiff. Now, understand these were made long back in the 80s, okay, 1800s. Now, in those times, if you imputed an infectious disease on somebody, nobody met that person, okay. And also remember the essence of defamation, that is, it is the reputation of the man in other person's eyes. So infectious disease in those age lowered the image of that person, okay. Imputation that a person is incompetent, dishonest, or unfit in regard to office, profession, calling, trade, or business carried on by him. So you hit his livelihood here, okay? An imputation of unchastity or adultery to a woman or girl is also actionable per se. This was as per the Slander of Women Act. So any imputation to a girl was also actionable. Now, what is the position in Indian law? It has been noted above that under English law, a distinction is made between libel and slander. And libel is a crime, slander is not. And in England, slander is only a civil wrong. Criminal law in India does not make any such distinction, and both are criminal offences. And in England, libel is actionable per se, but slander only in case of special proof. There has been a controversy whether slander like libel is actionable per se in India or special proof is required. However, authorities in India is for discarding between libel and slander in India and making both of them actionable per se. So the law in India is that both of them are actionable per se, both of them are actionable. There is no differentiation between the two in India. Now, what are the essentials of defamation? What is required for you to prove defamation? First is there must be a statement which is defamatory. Now, there has to be some statement which is made. Without any statement or anything being said, there can be no defamation, correct? So, there must be a statement which is made which is defamatory. And by defamatory, we mean that it is something that injures the reputation of the person. It must refer to the plaintiff. It must not be said to somebody else without referring to the plaintiff, or in air somebody says something and you take it upon yourself. No, it must refer to you for it to be made actionable by you. And it must be published. By publication makes the other person read it. Now we'll see what is publication exactly. Not in publication, not in the sense that you might think that it must come in the paper only or something like that. A simple letter written to somebody can also be a publication if somebody else reads it. In certain circumstances, we'll see that. We'll see that through case. Now, essentials. First is that the statement must be defamatory. Defamatory statement is one which tends to injure the reputation of the plaintiff. So, something that injures or something that damages the reputation of a person. Defamation is the publication of a statement which tends to lower a person in the estimation of right thinking members of the society. So, you lower the image in whom? In the right thinking or reasonable class of society, not a specific group. It is a general society we look at, or which tends to make them shun or avoid that person. So something that makes them avoid you is also actionable. An imputation which exposes one to disgrace and humiliation, ridicule, or contempt is defamatory. So something that makes others ridicule you or disgrace you or humiliate you is defamatory. The defamatory statement should be made in different ways. It can be made in multiple ways. It can be by simply saying two words, or saying, comparing you to somebody else, or making a statement which is what we know as innuendo, that in the plain language it looks like not defamatory, but it is defamatory otherwise. Okay. For instance, it may be oral, in writing, printed or exhibited by a picture, statue, or edify, or by some conduct. So it can be either, you might say it, we've understood there's no distinction between the two now. Or you, in a speech you are saying it, in some place you are saying it, or you write it and print it, or you put a picture somewhere which compares you with somebody else, or a statue is made, or a jiffy, or some actions are done which portray something to be defamatory. Okay. Thus, if a municipal corporation, out of ill will and malice and without justification, served a notice of distraint warrant, seized furnitures and book of a practicing advocate, the conduct amounted to defamation. You serve a notice without any justification, you take away the books. That lowered the image of the advocate in everybody else's eyes, and that's why it became defamatory. Whether a statement is defamatory or not depends on how the right thinking members of the society are likely to take it. So, in the normal, reasonable members of the society in which you live, how do they perceive that statement? That is what is of a benchmark here. So, the benchmark is right thinking members of the society. The standard to be applied is that of a right-minded citizen, a man of fair average intelligence, and not that of a special class of persons whose values are not shared or approved by the fair-minded members of the society generally. So there may be a group of people or some people whose values are not shared like those of others. So it is the general public whose values are to be taken account of. If the likely effect of the statement is the injury to the plaintiff's reputation, it is no defense to say that it is not intended to be defamatory. See, intention does not matter in defamation. If you say something and it injures somebody's reputation, later on, if you say, I did not intend it, that reputation is damaged and you will have to pay for it. When the statement causes to anyone to be regarded with feelings of hatred, contempt, ridicule, fear, dislike, or disesteem, it is defamatory. The essence of defamation is injury to the person's character or reputation. So, the main crux here being that you are causing an injury to the reputation of the person. Now, innuendo. Now, what is innuendo? Innuendo is a statement that on the face of it, a prima facie may be not defamatory. Okay, but the secondary meaning is defamatory. Okay, so prima facie it's not defamatory. We'll see how. A statement may be prima facie defamatory, and that is so when its natural and obvious meaning leads to that conclusion. So if it's naturally defamatory, it's okay. But sometimes statement may prima facie be innocent, but because of some latent or secondary meaning, it may be considered to be defamatory. So on the face of it, they may be innocent, but the secondary meaning may be defamatory. When the natural and ordinary meaning is not defamatory, but the plaintiff wants to bring an action for defamation, he must prove the latent or secondary meaning, that is the innuendo which makes the statement defamatory. So on the face of it, the statement was not defamatory, but you have to prove in case you bring an action for defamation in cases of innuendo that what was that secondary meaning, and were others also able to understand secondary meaning or not. Even a statement of commendation may be defamatory in the context of which it is said. Now, for example, why is a saint may be slander if the statement was understood to refer to a criminal gang known as the saints. Okay, so you refer, oh, he's like the saint, and that saint is what? A criminal gang. Similarly, to say X is an honest man and he never stole my watch may be a defamatory. If the person to whom the statement is made understands from this that X is a dishonest man having a watch, or the statement that a lady has given birth to a child is defamatory when the lady is unmarried. Similarly, a statement that A is like his father may be defamatory if it is likely to convey the impression that he is a cheat like his father. So he might be proven criminal or something. And then you say it. So on the face of it, you are like your father is not defamatory, but the intention or the way you said it meant that you are like your father in that context. Okay. When the innuendo is proved, the words which are not defamatory in the ordinary sense become defamatory. So if you're unable to prove the innuendo, those words also become defamatory. In Tolley versus JS trial, the plaintiff was a famous amateur golf champion. Now, he sued the defendants for libel contained in an advertisement for the defendant's chocolate. In the middle of the advertisement, there appeared a caricature of Mrs. Tolley hitting one of the most vigorous drives with a carton of Fry's chocolate sticking prominently out of his pocket and a comic caddy dancing with another carton of Fry's chocolate in his hand. And comparing in droggled verses the excellence of the drive with the excellence of the chocolate. The plaintiff had not been consulted and he had also received nothing in respect of the advertisement. So he was not consulted also, he did not get any money. Para 4 of the statement of claim said the defendant thereby meant and were understood to mean that the plaintiff had agreed or permitted his portrait to be exhibited for the purposes of the advertisement of defendant's chocolate. This shows that you agreed to do it. Otherwise, without your permission, nobody would do it. And they had done so for gain and reward. That he had prostituted his reputation as an amateur golf player for advertising purposes. That he had been seeking notoriety and gain by means of the, and he had been guilty of conduct unworthy of his as an amateur. The plaintiff said by the said advertisement he suffered his credit and reputation. It was held to be an innuendo, and the plaintiff had prostituted his status for advertising was supported by the fact, and advertisement was therefore defamatory for a man of his position. As I said earlier, intention to defame, not the. When the words are considered to be defamatory by a person to whom the statement is published, there is defamation, even though the person making it believed it to be innocent. It is immaterial that the defendants do not know of the facts because of which a statement otherwise innocent is considered defamatory. Information. To show this, the case of Cassidy, the Daily Mirror newspaper. Mr. Cassidy, also known as Mr. Corrigan, was married to a lady who called herself Mrs. Cassidy. Corrigan. She was known to be the lawful wife of Mr. Cassidy, who did not live with her, but occasionally came and stayed with her at her flat. The defendants published in their newspaper a photograph of Mr. Corrigan and Miss X with the following words underneath. Mr. M. Corrigan, the race horse owner, and Miss X, whose engagement has been announced. So, what does this prove? That Mr. Corrigan is getting engaged to somebody else, and this leads to a conclusion to mean that Mrs. Corrigan, claiming to be Mrs. Corrigan, is not the lawfully wedded wife or living not in a marriage with the man. Mrs. Corrigan sued the defendant for libel, alleging that the innuendo was that Mr. Corrigan was not her husband and he lived with her in an immoral cohabitation. Some female acquaintances of the plaintiff give evidence that they have formed a bad opinion of her as a result of the publication. This was the innuendo. Jury found that the words conveyed defamatory meaning and awarded damage. The Court of Appeal held that the innuendo was established. The obvious innocence of the defendant was no defense, and the defendants were held liable. So, the fact that you had no knowledge or you were not doing it with intention is immaterial because this has caused reputational damage to somebody. What are the essentials of defamation? Now, let's see the second essential. The first is the statement must be defamatory. The second is the statement must refer to the plaintiff. Why refer to the plaintiff? You cannot defame somebody in thin air. If in an action for defamation, the plaintiff has to prove that the statement which he complains referred to him. So it is referred to. It is immaterial that the defendant did not intend to defame the plaintiff. The intention to defame somebody is not. If the person to whom the statement was published could reasonably infer that the statement referred to the plaintiff, the defendant is liable. Can have a reasonable inference that you are referring to somebody, defamation is possible. Acting in good faith and without intention to defame is no defense. We've already read this. Intention of the writer is quite immaterial in considering whether the alleged matter is defamatory or not, even in considering whether there is defamation or okay. So whether it is defamatory of the so intention is immaterial. How you write is immaterial. The fact that something is done, if you do it in good faith, it's immaterial. In the Newstead versus London Express newspaper, the defendants published an article stating that Mr. Horland, Newstead, and a Campbell man had been convicted of bigamy. So a Camberwell man was convicted of bigamy. The story was of Harlot Newstead, a Camberwell barman. Okay. The action for defamation was brought by another Harold Newstead, a Camberwell barber. What did the Newstead, this is the paper, clarify which newstead person was he, a barman, was he a barman, a barber. There was no clarification as such. You just published the name, and somebody with the same name made a case, because why? Others thought that he was being referred. As the words were considered to be understood as referring to the plaintiff, the defendant got held. Here, the only thing that had to be done was comma barman. If you wrote barman, the barber would not have been able to bring the case. Okay. It has been noted above that the liability for defamation did not depend upon the intention of the defendant, but upon the fact that the statement made by him was considered to be defamatory by normal people of the society guidelines. This creates a lot of hardship for many innocent authors and printers and publishers, because the fact that they were innocent in publishing the statement did not protect them from the liability. And in the last cases also, Cassidy case also, we've seen that there was no intention to defame, but yet you were held liable. Now, what happens when you defame an entire class of, we've already understood that you must be referred. The plaintiff must be referred. So, what happens if there is an entire class? Lawyers as a class, doctors as a class. What happens in those? When the words refer to a group of individuals or class, no member of that group or class, unless he can prove that the words could reasonably be considered to be referred to him. So, unless you prove that the words refer to you, cannot be held. You cannot bring a case for defamation. Thus, if a man wrote that all lawyers are thieves, no particular lawyer could sue him unless there is something to point to that particular individual. So you have to prove that that statement was made for me. A class cannot be defamed. Knopfler versus London Express newspaper. Appellant was a member of a party, the membership of which was about 2,000, and out of which 24 members, including the plaintiff, were in England. So out of 2,024 were in England. Now, the newspaper made a statement for the whole party, and some of the friends of the person, Knopfler, some of his friends thought that the article was referring to some of the friends. Okay. Now, what we've understood, it has to be the right-minded people of the society. If some particular class is saying, it may not affect. Okay, so this is another example of that. It was, however, held since the article referred to such a big class, most of the members of which were residents abroad, it could not reasonably be considered to be referring to the appellant and the held liable. In this case, Lord Atkins stated, there can be no law that a defamatory statement made of a firm or a trustee or the tenants of a particular building is not actionable. Okay? If the words will reasonably be understood as published of each member of the firm or each trustee or each tenant, so the fact that it is referring to a group per se does not make it non-action. Okay, but you have to show that that group, may it clearly mention that it is referring to each member of that group. The reason why a libel published of a large or indeterminate number of persons described by some gender generally fails to be actionable is the difficulty of establishing that the plaintiff was in fact the defamatory statement. How do you prove that you were a part of that defamatory statement for which was made, that it was referring to you? So it has to refer to you. Okay. Now, what happens in case of a defamation class also cleared in the case of Dhirendranath Sen versus Rajat Khan. It was held that when an editorial in a newspaper is defamatory of a spiritual head of a community, an individual of that community does not have a right of here, that person, that spiritual head himself has to bring action. Where the statement, though generally referring to a class, can reasonably be considered to be referring to a particular plaintiff, his action will succeed. His action, right? So he himself has to. A partnership firm is not a legal entity, unlike a company. Company is a legal entity, a partnership is not. partners collectively are known as the firm. Definition of partnership firm may therefore mean definition of the partners of that firm. No suit for defamation is maintainable by a firm as it is not legal. This has to be brought by the individual partner. Why? Because firm is not a legal person. Unless you are a legal person, you cannot go. When we read capacity also we understood that partners have to bring that. Okay. What happens is became a disease or a death. There is no law in torts or no provision in torts to defame a disease. However, under criminal law, it may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living. Okay? Now, if somebody is living, that reputation is harmed, or is intended to hurt the feelings of the family or other members, your relative. If you are not living, then it is intended to hurt the feelings of the family and near and the third essential of defamation is that the statement should be published. You must publish the statement. What do you mean by the statement that statement should be published? Publication means making the defamatory matter known to some other person other than the person being defamed. And unless this is done, no civil action for defamation lies. So basically, if somebody makes a statement about me, that any third person should know about it. If somebody is making a statement about me to me, there is no defamation. But if you tell it to some third party, that third person knowing also becomes a defamation. Communication to the plaintiff himself is not enough because defamation is injury to the reputation, and reputation consists the estimation in which others hold him and not a man's own opinion of himself. So you should not tell it to somebody else, some third party. Dictating a letter to one's typist is enough publication. Why? Because you've told it to the third party. Sending the defamatory letter to the plaintiff in a language supposed to be known to the plaintiff is no defamation. So that language is only known to the plaintiff. You send that letter to the plaintiff also. If somebody sends me a letter, I am supposed to open it. If somebody else opens it, that is not defamation. Why? Because it was not intended for somebody else. You did not intend that somebody else reads. If a third person wrongfully reads a letter meant for the plaintiff, the defendant is not liable. If you wrongfully read somebody's letter, then there is no defamation. However, for example, if I sit in an office and there is a routine that every letter which comes to me, my office staff opens it, reads it, and if it's important, gives it to me. And you know that for a matter of fact that this is how it happens, then it can be defamation. When the father opened his son's letter, or a butler opened and read a sealed letter meant for his employer, there was no publication by the defendant and he was not liable. If a defamatory letter sent to the plaintiff likely to be read by somebody else, there is public. Like I said, there is a pattern which you know that this is how it happens. Then it will be defamation. When the defamatory matter is contained in a postcard or a telegram, why? Postcard or telegram, everybody reads. The defendant is liable even without the proof that somebody else has read it, because a telegram is read by the post office officials who transmit and receive it. Telegram is read by somebody else, and there is high probability of a postcard being read by someone. Postcards are meant to be read. Generally, people read postcards. If, however, the matter contained in the postcard could not be understood as defamatory by a stranger, unacquainted with certain circumstances not mentioned in the postcard, there was no publication to the postman or other person whose hand the card passed. Why? What does it mean? For example, a matter is defamatory only if you know the context. If you do not know the context, it does not. In that cases, what happens? In that case, it is defamatory because you did not know the background. The same. Similar would be the position if the matter is in a language which the addressee does not understand, or he is too blind to read it, or could not hear, being a deaf man. Obviously, if you could not read it, there is defamatory matter in front of you. Does not. If you are deaf, you cannot hear. Some defamation in front of you. Does not. When the libellous letter addressed to the plaintiff is in the ordinary course of the business, likely to be opened by his clerk or by his spouse, there is defamation. When the clerk or spouse opens the letter and we've already discussed, there is no publication when the defendant knew or ought to have known that the letter already sent to the plaintiff will be read by a third person. Example, it is written in a language which the plaintiff does not. So I write a letter in a language which is addressed to a person who does not read or understand that language. Obviously, he will go to somebody else, get that read. I know it for a matter of fact that you will not do. Then it will be defamation. Communication between husband and wife. They are confidential. And if I tell my husband and wife something, they are not considered to be defamatory. It is not considered to be publication. In the eyes of law, husband and wife are one person, and the communication of defamatory matter from the husband to the wife or from the wife to the husband is no public. In the case of T.G. Ponin versus M.C. Varghese, what happened is the husband wrote some letters. T.G. Ponin wrote some letters to the wife, his wife, Rat, and they were about his father-in-law, M.C. Varghese, and something defaming him. Okay. Now the wife gave those letters to her father, and he launched a case of defamation against T.G. Ponin, saying that he has written defamatory matter. It was contended and it was held also that the letters were addressed to the wife, and without his consent, they were first inadmissible in the court of law, and the wife was not allowed to disclose it to somebody else, and hence no defamation case was made. Now, what happens if there is a repetition of a defamatory matter? Each time somebody repeats it, a fresh cause of action arises. That's why it said publication. Okay. Now, the liability of a person who repeats a defamatory matter arises in the same way as that of the originator, because every repetition is a fresh publication giving rise to a fresh cause of action. So, every time you repeat it, there is a fresh cause of action. Not only the author of the defamatory matter is liable, but also the editor, printer, publisher are liable in the same way. Why? The editor is responsible. Editor, printers, and publishers are responsible to know what they are publishing. Editor is in fact responsible to read each and every line before you finalize it. The publisher cannot publish anything without knowing what has been written. You cannot defame somebody. You must ought to have knowledge. Okay. However, if somebody has published something or done something, okay, and you do not know about that being defamation, it has come to you in the normal routine. You sell newspapers, and that newspaper has come to you in the normal course of action. Okay, then you will not know if there is something defamatory, or even if you applied reasonable diligence, there was no way of knowing that you are circulating something defamatory, then you will not be liable. In whose cases? Somebody who's selling them. So, booksellers, newspapers, and vendors. This class of person, law has a lenient approach. If they did not know, or in spite of reasonable diligence, could not have known what they were circulating, then it is not was defamatory, then it is not a responsibility for them. They are not liable. Now, indemnity from the supplier of wrong. Now, you cannot claim indemnity unless and until you have a contract that you should only get correct. It was held that if a person supplied wrong information, incorrect information, and the editor is convicted for the same, the editor cannot claim indemnity from the supplier of the information unless you have a contract to that effect, because the editor does not have a legal right to get only correct. Whenever you get news, you are ought to get it verified. It is observed that it is the duty of an editor of a newspaper to check up the news or the information that is supplied to him before publishing the same in his paper. especially when the news is defamatory in nature. Okay, why? Because ultimately it is the editor who will be held responsible for publishing the defamatory matter. If he does not do that, he has to suffer the consequences of his neglect. So you will have to be liable. Now, what are the defenses? There are three defenses: justification or truth. If there is something which is a true statement, you cannot say it's defamation. Making a statement of fact is no defamation. A fair comment, you made a fair comment and you did not want defamation, we'll see how it happens. Now, there are certain privileges, parliamentary privileges, privileges, they may be absolute or they may be qualified. These are three categories of defenses available in the cases of defamation. Now, the first defense of justification or truth. In a civil action for defamation, truth or the of the defamatory matter is a complete defense. So, in case there is a truth in the matter, it's obviously a statement of fact then. Under criminal law, however, merely proving it true is no defense. The first exception to Section 356 of BNSS, which has replaced the IPC, requires that besides being true, the imputation must be shown to have been made for public good. So, if there is no need to make a defamatory statement, which is even in fact true, you should not. You should only make it when there is a public good associated with it. Under civil law, however, that is under torts, merely proving the statement was true is a good defense. Okay, so the fact that the statement was true is enough under civil law. The reason for the defense is that the law will not permit a man to recover damages in respect of an injury to the character which he neither does or ought to possess. So something will not be injurious to your character if you don't possess that character. Okay. The defense is available even though the publication is made maliciously. Even if you make it with ill intent, then also you will have that defense. If the statement is substantially true but incorrect in respect of certain minor particulars, the defense will still be available. Substantially true, but certain minor problems, it will yet be true, the available defense. Now, what do you understand by truth? We'll see it through a series. If the defendant is not able to prove the truth of the fact, the defense will not be available. So you cannot prove it to be true, you will not. In Radheshyam Tiwari versus Eknath, now this is how and what are facts we will see. The defendant, who was the editor, printer, and publisher of a newspaper, published a series of articles against the plaintiff, a block development officer, alleging that the plaintiff has issued false certificates, accepted bribe, and adopted corrupt and illegal means in various matters. Now, when an action was brought in, he could not prove that these were true. He just made statements and he was held liable. Okay. The second being fair comment. What do you understand by fair comment? A comment in public interest. Making fair comment on matters of public interest is a defense to an action for defamation. Now, what is required to be for an action of fair comment? First, that it is a comment. That is an expression of opinion, rather a assertion of fact. You have made a expression of an opinion on something. You've not made a fact. So the way you say it makes it clear. It must be fair. That is, it must not be with malice. It must not be with any ill will. It must be good intention and good faith. And the matter commented upon must be in public interest. There must be public interest associated with the same. Now, what is comment? Comment means an expression of opinion on certain facts. It should be distinguished from a statement. So you have an opinion that is different. So I say, I am mad. This is a statement of this state comes across as a statement. I did this, I must be mad to do this. An opinion that why did I do this? Only I must be mad. Okay. A fair comment is a defense by itself, whereas if it is a statement of fact that can be excused only if there is justification or privilege proved regarding. So if it is a statement of fact, you only have a justification of truth or a privilege. And a fair comment by itself becomes a defense. Whether the statement is a fact or a comment on certain facts depends on the language or the context. I said the tone or the language or context in which it is. For example, A says of a book published by Z, Z book is foolish. Z must be a weak man. Z's book is indecent. Z must be a man of impure mind. These are only comments which are based on the assertion from Z's book, and A will be protected if he says it in good faith. Okay. Now, however, since it is necessary that the comment must be related to certain facts, it is also essential that the fact which is commented upon either must be known to the audience or you must tell that to the audience before making the statement. If the person does not know the statement or the fact before a comment is made, that statement itself becomes a statement of fact for the audience. For example, X says that A has been held guilty of breach of trust and therefore he is a dishonest. The latter words are comment on the former. Okay, okay. So you say that somebody is held guilty of trust. Okay, that's why he's a dishonest. But if the former words are not known to the audience and you just say A is a dishonest man, it is not a comment but a statement of fact, and the plea of fair comment in such cases cannot be made. Okay, there must be something. I say I'm mad. A statement of fact. I have done so and so. I must be mad to do it. The fact and then the comment. Okay. Now, it must be fair. Comment cannot be fair when based on untrue fact. So you have to say it on true fact. A comment must be based upon invented and untrue facts. No, is not fair. So something based on untrue facts is not fair. Thus, in the review of a play, when immorality is imputed by suggesting that it contained an incident of adultery, when in fact there was no such incident, the plea of fair comment cannot be. So you make a comment on a play saying that it was immoral when there was nothing as such which was immoral. It cannot be a fair comment. Similarly, if in a newspaper there is publication of statement of fact making serious allegations of dishonesty or corruption against a person, the defendant is unable to prove the facts are true, then a comment made on untrue facts is also not a fair comment. So the facts must be true. In case of fair comments, if the facts are substantially true and justify the comments of the fact which they are truly stated, the defense can be taken even though some facts may not be. So if it is substantially true, like in the earlier case we had said justify, if it is substantially true, then this defense can be taken. Whether the comment is fair or not depends on whether the defendant dishonestly held the particular opinion. Okay, sorry, honestly held that particular. So if you honestly held that opinion, does not depend. If the opinion, it is not the opinion of the court as to fairness of the comment, but the opinion of the commentator, which is real. Your opinion, fact का true होना जरूरी है और opinion की बात करनी. Okay? If due to malice on the part of the defendant, the comment is distorted one, his comment ceases to be fair and cannot be taken. The defense. I said good faith. Okay. Now, it must be in public, not random comment. The administration of government departments, public companies, courts, conduct of public men like ministers or officers of the state, public institutions and local authorities, public meetings, pictures, theaters, etc. are considered of public. It must be in public interest, private. Okay? The last being privilege. There are certain occasions when the law recognizes that the rights of free speech outweigh the somebody's right to reputation, right to freedom of speech and expression more than the right of reputation. The law treats such occasions to be privileged. So these occasions are called privileged occasions. And defamatory statement made on such occasion is not actionable. If you make a defamatory statement such cases, it will not be will. Privilege can be of two kinds, absolute or qualified. In absolute, any statement made not actionable. In qualified, there are certain exceptions. Absolute privilege. In matters of absolute privilege, no action lies for the defamatory statement, even though the statement is false or made maliciously. Okay. In such cases, public interest demands that an individual's right to reputation should give way to freedom of speech and expression. That's why, in what things people say in parliament or in judicial proceedings, not action, because you have complete freedom. The absolute freedom is recognized in the following cases, these two cases: parliamentary proceedings and judicial proceedings. Parliamentary Article 1052 of our Constitution provides that statement made by a member of either house of the parliament in the parliament and the publication by or under authority of either house of parliament of any report, paper, votes, or proceeds cannot be questioned in the court. And similarly, 194(2) gives the privilege to state legislatures. So anything made or said in the parliament cannot be questioned out. In judicial proceedings, no action for libel or slander lies whether against judge, counsel, witness, or parties for words written or spoken in the course of any proceeding before any court recognized by law, even though the words written or spoken maliciously without any justification or excuse, and from people personal ill will and anger against the person defamed. So anything said cannot be questioned, but it should not be lies. If you write lie under judicial proceedings, you will see what are the consequences. Defamation is one thing, lies is something. Such a privilege also extends to proceedings of tribunals possessing same attributes. Okay? Judicial proceedings. Protection to judicial officers in India has been granted under the Judicial Officers Protection Act 1850. The counsel has also been granted absolute privilege in respect of any words spoken by him during the course of pleading of the client. However, they must be relevant words, not irrelevant. You cannot speak anything. However, if the spoken words by the counsel are irrelevant and not having any relevance to the matter, it is not a defense to say that it is a qualifier. It's a privilege. It's absolute privilege. Then you will not have a privilege. The privilege claimed by the witness is also subject to a similar limit. A remark by the witness which is irrelevant to the matter is not a privilege. The defamatory remarks by a person may be considered to be relevant if it is an attack on the character. May be considered to be relevant if it's an attack on the counsel's character, who also happens to be involved in criminal proceedings which are conducted in the court. A statement made to the police officer, which the complainant, if so required, willing to substantiate upon, is also absent. Something you are able to substantiate. All statements made by potential witnesses as preliminary to going into witness box are equally privileged with when the statements are made actually in the box of the court. Okay. Now, state communication is the third. A statement made by one officer of the state to another is an absolute privilege for public policy. Such privilege also extends to reports made in the course of military duties, communication relating to state matter by one or more minister or by the minister to the crown. Okay, so state communications are also absolute. We go on to qualified privilege. What is qualified? In certain cases, a defense of qualified privilege is also. Unlike the defense of absolute privilege, it is necessary that the statement should be made without malice. For such a defense to be available, it is further necessary that there must be some occasion for making it. For example, my friend is going to keep somebody as a associate, and he asks, how is that person? And if I give a true image and that person is not hardworking, not a good person, not a decent person, if I tell my friend about it, it is a qualified privilege. Why? Because I told him about that person because I had an occasion for me. Okay. Generally, such privilege is available either when the statement is made in discharge of a duty, a protection of an interest, a publication is in the form of a report of the parliamentary, judicial, or other public. To avail the statement defense, the defendant must prove 2 points. The statement was made on a privileged occasion. That is, it was for discharge of a duty, a protection of an interest, or it was a fair report of a parliamentary, judicial, or a public proceeding, and it was not with any malice, it was with good. Now, what do you understand that the statement should be made in discharge of a duty or protection? The occasion when there is a qualified privilege to make a defamatory statement without malice are either where there is an existence of a legal or social or moral duty to make such a statement. Like in the example I said, my friend was asking, I had a moral duty to tell my friend, okay, on existence of some interest for the protection of which the statement. I wanted to protect my friends. A privileged occasion is in reference to qualified privilege, an occasion where the person who makes a communication has an interest, legal, social, or moral, to make it to the person, and the person to whom it is made has a correspondent interest or duty to receive. There is reciprocity, which is my friend had an interest to know, and I had a duty to tell, a moral duty or a social. Statement should be made in the discharge of a duty of protection. Rest has also been upheld by Section 356 BNS, Exception 9. It is not defamation to make an imputation of character on the character of another, provided that the imputation be made in good faith for the protection of the interest of the person making it or of any other person or for public. For example, these are illustrations of BNSS. A shopkeeper says to B, who manages his business, sell nothing to Z unless he pays you ready money, or for I have no opinion for his honesty. A is within the exception if he has made this imputation on Z in good faith to protect his own interest. A magistrate making a report of his own to making a report to his own superior officer casts an imputation on the character of Z. Here, if the imputation is made in good faith and for public good, A is within the exception. Now, a former employer has a moral duty to state a servant's character to the person who is going to employ him. The person receiving the information also has an interest in this, so there is reciprocity. The occasion is therefore privileged, but if the former employer, without any inquiry, publishes the character of his servant with a motive to harm the servant, there will be no privilege. Similar protection is granted to a creditor who makes a statement about the debtor's financial credit condition to another creditor. Reciprocity here. In case of publication of libelous matter in a newspaper, duty to the public has to be proved. Okay, if you make it paper, you have to prove the duty to the public. If such a duty is not proved, the privilege is failed. The plea will also fail if the plaintiff proves the presence of malice or ill motive or evil motive in the publication of the defamatory matter. The reciprocity of duty or interest is essential. So it is essential that there is a reciprocity of or interest. Such a duty or interest must be actually present. It is not sufficient that the maker of the statement honestly believed in the existence of such a duty. Okay? It has to be, in fact, present. You cannot yourself go and say, no, I thought I should tell you this. No, it has to be present. The person should come and ask you, then it is that it is. When X has an interest in the statement but not Y, the defense of qualified privilege will be successful in respect of a publication to X but not regard with the same to Y. So there are two people to whom I make the same statement. One is a potential employer, one is somebody else. That interest is for the potential employer if I make it for a person's character for employment, but not to the second person who had no interest in them. Issue of a circular by the defendant to their servant stating the dismissal of the plaintiff for gross neglect in the performance of duties covered by the privilege if the same had been made without any malice, because it is in the interest of the defendant that their servants know the consequences of gross. Such communications may be made in case of confidential relations like those of husband and wife, father and son, or daughter, guardian, ward, master, servant, or principal. Thus, a father may acquaint his daughter about the character of a man. Obviously, if she wants to marry somebody, the father has to tell. Now, the last category, reports of parliamentary judicial proceedings or other publications. These are subject of absolute privilege. However, if the proceedings are published without the authority of the House, qualified privilege can be claimed, provided they are made without any malice and in good faith. So, if the Parliament themselves publish it, it is absolute. If somebody else does it, you have to prove that you did it in good faith without any malice. Apart from that, publication of judicial and quasi-judicial proceedings and proceedings of public meetings also enjoy qualified. So, apart from this will also be qualified privilege. Now, although the conduct of private individual may be subject of such proceedings, his interest is considered to be subordinate to public interest of making known the matter of public importance, and the general public interest more than counterbalances the inconvenience to such a private individual. So, one person's inconvenience cannot be over the general public. Report of a commission which is set up to inquire into matter of public interest can also be similarly published if it appears that it is in public interest that it should be published. So, if something is established to, for example, examine the environmental things or some public interest matters, those reports can also be published. The privilege does not extend to reports of court proceedings which are not of public interest or to proceedings to which the public is not admitted. So, private published, and if you publish, you cannot claim defense. Okay. Publication Parliament. In the Parliamentary Proceedings Protection Publication Act 77 grants qualified privilege to publication of proceedings of the Parliament. So it says, no person shall be liable to any proceeding, civil or criminal, in any court in respect of publication in a newspaper of a substantially true report of any proceeding, either of either House of the Parliament, unless the publication is proved to be made with malice. Okay? So, unless you do it for good faith, you cannot have the protection. Thus, to claim privileges for parliamentary proceedings, it should not be with malice and should be for good faith. What do you mean by statement should not be without? In the matter of qualified privilege, exemption from liability for making defamatory statement is granted if the statement was made without. Okay, malice destroys everything, and malice means ill motive. Horrocks versus Law. In this case, it was held, howsoever prejudiced the defendant may have been, or howsoever irrational in leaping to conclusions unfavorable to the plaintiff, but if he believed in the truth of what was being said, the defense is available. If there was no prejudice, is something else, and malice. Statement should be made without malice. Lord Diplock explained the malice needed to destroy the defense of qualified privilege in the following words. Broadly speaking, it means malice in popular sense of desire to injure the person who is defamed. And this is generally the motive which the plaintiff sets to do. But to destroy the privilege, the desire to injure must be the dominant motive for the defamatory public. Knowledge that it will have the effect is not enough. If the defendant nevertheless, acting in accordance with the sense of duty or bona fide protection of his own legitimate interest. So everything which is defamatory and published will injure somebody's reputation. But the dominant motive should not be that. The dominant motive should be to protect your or somebody else's legitimate. Then it will not be with malice. Okay? The notice with which a person published defamatory matter can only be inferred from what he did or said or no. If it be proved that he did not believe that what he published was true, that is generally conclusive evidence of express malice. For no sense of duty or desire to protect his own interest can justify a man in telling deliberate or injurious falsehoods about others, save in exceptional cases where the person may be under duty to pass or endorsing the report made by some other. So, this is about malice. This was in detail about defamation. What is defamation? What are the essentials? What are the exceptions?